afternoon when the sun is going down. So I expect you to fall asleep in the next half an hour or so. If I do fall asleep myself, please wake me up. If you see me going like this when I'm talking, just say, Luca, please keep on. I think we should aim at finishing at about 5:30. So, and it's been about the most technical part, most, I would honestly say, legal-oriented one. Let me know, who are the lawyers present in the room? Right, don't be shy, it's not so bad. Lawyers. Legal, that's illegal. Okay. So I apologize for the rest. It's going to be you hopefully enjoy the part on the social media more than the legal one. But anyway, so this is the uniform disclosure policy. So should you have an infringement ongoing online, what do you do? How do you solve the problem? Say someone is infringing your Gucci.sexy domain name. This is an example we'll see tomorrow morning, late morning. And more interactive part tomorrow. But this part has to be done because it's supposed to be covering the technical issue, which is the basis to understand better the procedure we'll explain tomorrow. So I apologize. But more in general, as an introduction, how do you tackle Gucci.sexy online? Or infringement online? Yes, there are different steps.
Actually, first step you have to contact the registry and check the procedures for such an issue. If they have an internal UDRP program, and if something not, you can go for I can provide.
Any other idea on approaches?
I think there's something about online mediation, so I took lately, and the online arbitration. Maybe it explains.
As well.
If I have registered the brand itself, I can apply the court to national courts.
National court as well. Yes. I forgot I'm tied to a web speaker. Yeah? Oh, very good. Congratulations. Complaint in different ways. So you have different tools and different ways to tackle issues online. First one would be something that lawyers always tend to forget, is the out-of-court settlement. Don't forget that your clients will love you if you manage to solve the matter quickly and without making them spending or investing in you a lot of money. I know it sounds bad for you, but it's a long-term investment in my view, a relationship with a client. So if you manage to solve the matter quickly, and maybe with a good out-of-court settlement like this, they will then trust you more work. So don't be shy of thinking to approach the issue with a good out-of-court settlement. You get in touch with the owner in different ways, we'll see them in a minute, and you reach an out-of-court settlement. If it doesn't work, of course, you have mediation and arbitration, what our colleague was mentioning. So these are, of course, big tools available for all sorts of infringement ongoing as well online, as well in the real world. So you can always go to mediation. You recall the difference between mediation and arbitration? You do?
Yes.
Good. So basically, as you know, mediation is a procedure whereby you entrust someone to help you to some extent to reach a solution, but you still hold the decision in your hands. I had a fantastic mediation done some years ago, and I tell you this anecdote because I'm supposed to tell anecdote every now and then. And the mediation was fantastic because I had a Sicilian party and an American. Can you imagine more different way to think as a Sicilian former distributor of the American company producing devices or irrigating grounds? Termination of the agreement of the American company. Sicilian says, you know what, I'm going to do the same. I'm going to call the device in a similar matter, and then I'm going to flood the market at half price. Then you talk about it. And that was pretty much what he did. He was keeping on producing the same exact stuff, calling it slightly different way, and flood the market at half the price. How do you mediate this kind of stuff? They were in court, millions of euro worth of stuff, and one of the lawyers had the idea to entrust the matter into mediation. And the lucky one was me. I'm a mediator as well for WIPO. So how do you tackle this kind of issue? You have a Sicilian guy, very angry, an American company, not even talking to one another for years. You have them all in the room, lawyers, the two parties and yourself, and try to make them talk. You try to facilitate the discussion by different techniques. You make the lawyers talk first, so that legal stuff is done. Then you ask the lawyers, now you interpret his role and you interpret her role. And they start very, hey, what is that? And then all of a sudden, the parties started to talk to one another, saying the lawyer are useless. Sometimes we are, not in the bad sense, but meaning that they have to take a decision. Lawyers can help clients to take a decision, but the decision is in the hand of the actual managers. So in mediation, it's always very important to have people who can take decisions. So they start talking to one another, and the mediation went fine. At the end of the day, we reached an agreement. I took them for dinner while the lawyers were drafting the mediation agreement. The following morning was supposed to be just a quick and easy breakfast meeting, and then off we go. Sure enough, the draft agreement by the lawyers was not really in line according to them, what we discussed before. So about 1 o'clock in the afternoon, we were supposed to close at 5. The Sicilian guy stands up, slams the hand on the table, and in a strong Sicilian accent said, "You're making fun of me," or "Aqui mancadas de burbulo." And he was actually physically walking out of the room. So I had to physically drive him back to the room and make him talk again. At the end of the day, we reached an agreement, but it was them reaching an agreement. It was only me trying to make them think about solutions. They're still in business now after 6 years, and they do work with them. But this is one way to solve the problem, which is not always easy to handle, because party can be very angry, can be very personal. In that case, you have arbitration, in which you entrust a guy like myself again to take a decision. So we still have the Sicilian and the Americans in the same room, but they say, "Look, you take a decision for us." We sign an agreement about you take the decision, and we're basically going to obey it. Issue of enforcement is regulated by the New York Convention, and this is somehow different. But this is a way in which the parties entrust either a third person to facilitate or a third person to decide. Court was mentioned by your colleague. Go to court. Certainly is a way, and online disputes are still as well solved and are solved and will be more solved by a court settlement, court decision. It may take some time. It can be a costly operation. So evaluate whether to go to court after you're done the out-of-court settlement attempt, and maybe consider mediation arbitration. And these are the, let's say, usual way of solving any matter as well in IP. In IP, though, we have another very efficacious tool, which is this uniform dispute resolution policy. This was a procedure we'll see in a minute, which we have available. It was handled and was basically introduced by ICANN. As you know, ICANN is as the authority in charge of the names and numbers, and as well decided to entrust this policy, which is supposed to be facilitating specific kind of infringement ongoing online. This was introduced in 1999. It was basically following a WIPO procedure, consultation procedure. I was part of it. I was working in this kind of field since a long time. I'm old, as you can judge. So I was already involved with WIPO in 97, 98. The document was issued in 1998, 99. And it was basically adopted by ICANN then, and is therefore applicable to all the domain registration. Because as you know, ICANN is managing the registries and entities in charge of the top-level domain. So we have, what was mentioned by Network Solution, and we have more people managing registration of generic domain names, or you have the entity in here, in charge of .eg. And basically those are the registry. Why at the end? They entrust a number of registrars, companies selling basically domain names. And these companies have an obligation toward the registry regulated by the ICANN contract, whereby they sort of comply to any policy, any procedure, which ICANN deemed appropriate to introduce. And this was introduced in 1999. Therefore, it has effect, rather strange for law, even retroactively. So you can apply the UDRP, that we're going to see in detail in a minute, to all the generic top-level domains and to all the new generic top-level domains we're talking about this morning. the 1,000 plus new extensions. So we're talking about a hefty amount of possible procedure. And not only that, because an increasing number of country code, we'll see them tomorrow morning as well, or many, have adopted this policy, either identical policy, 47, or variation, 54. And the policy is therefore applicable, with some variation, directly for many country codes developments. What is the procedure in Egypt? Did not adopt the WIPO procedure, didn't you?
Actually, as we are stuck with the documentation regarding any registration under .com or the second level domain, so
Yep.
we have a little bit problems regarding registration the domain for company and another company getting to say this is domain, it belongs to me.
Right.
But in general, we are going to deal with the new center in NTRA regarding any disputes. .mas and .eg have the same concept regarding solving any problems regarding registering the domain by any illegal way.
Okay, so you see, in each different country, for instance, Italy adopted a different system. We are special in Italy, so we didn't want to adopt the UDRP, but we adopted a procedure which was very similar, which is very similar to the UDRP, basically based on the same grounds. A long story short, this policy is incorporated into the agreement. So beneath or below the registrars are the registrants, NTS. All of us, people owning domain names. We want to have a studiobabel.com, we buy studiobabel.com.eg, maybe I can apply for it, have a trademark registration. .eg I can't because I don't have a valid trademark registration in Egypt, but still I can have it, and I'll be a registrant. I sign an agreement with the registrars, and therefore I should apply or suffer, so to speak, if I infringe your rights, this policy. So, again, this policy is now available in the country code. This is the list of the country codes in which this procedure was adopted, either identical or with some variation, and we'll see that tomorrow morning more details with the WIPO experience presentation, how the differences are made. But I'd like you to remember that this procedure is big. Now, and it is managed by 4 entities in the world. First one is World Intellectual Property Organization. Second one is National Arbitration Forum, NAF. Third one is the Asian Domain Name Dispute Resolution Center, based in Beijing, Hong Kong, and Seoul. And the last, more recently appointed, is the Czech Arbitration Court, terrible acronym, CAC, but approved in January 2008. So, this procedure is managed by these entities and these entities only. So if you have to file a procedure under the UDRP, you have to go to one of those. For the sake of my presentation, I will use the example of WIPO, but bear in mind that I'm saying any dispute resolution service provider can do the same procedure. We'll tell you some of the difference between I'm a pilot on actually WIPO, NAF, and CAC. So I'm not only finding there. But still, I'm working more with WIPO, so I will use that example of WIPO. But again, I'd like you to remember that this policy that we're going to see in details in a minute is handled by these entities. How does it work? So, if you fall asleep after the slide, is fine. But I'd like you to remember the content of this one. Maximum attention, because this is actually this slide telling you go, no go to a client. If you have this requisite, yes, we can do it. If you don't have it, let's think about something else. Right? So, A, to apply the UDRP, the domain name should be identical or confusing similar to a trademark in which the complainant has rights. Complainant, of course, is the owner of the trademark. So, first requisite of this policy, trademark registration. Second, the holder of the domain name, the pirate, does not have right or legitimate interest in respect of the domain name. And you have to prove it. So, the respondent cannot say, well, my name is, or I have a right on this signed. Third requirement, and I'd like you to focus the attention on the end here. The domain name has been registered and is being used in bad faith. So basically it's a third requirement which contains two, makes a total of 4, because it's tricky. You have to have the conjunction here. Bad faith has to be proven at the time of registration and in the use. Some of the country codes have adopted this policy to do something wiser than we did with the WIPO, and actually we did with ICANN in adopting this policy. Have it an or instead of an and. Because if you are registering a domain name, for instance, the time in which the domain name was, the trademark was not even existing, I have a client, a huge corporation, having a trademark now, which was not existent at the time the domain name was registered. I cannot use this policy. Why? Because I cannot prove bad faith at the time of registration. The trademark was not there. So this policy does not apply. If we would have 3 days to speak about this, as we do on the advanced UDRP course I teach in Geneva, we could go and analyze all the different kind of attempts that we did as finalists to interpret the rules in a different manner. But the fact of the matter is the same. Unless we have this conjunction requirement, we cannot apply the UDRP. So this is the slide I'd like you to remember when you think about UDRP. Trademark registration. Keep on bumping on this, sorry. But it's a major effect, so you remember. Trademark registration falling down of the microphone. Then you have holder of the domain name, no rights or legitimate interest, and bad faith at the time of registration and in the subsequent use. Now we can go home. Just kidding. Now, yes.
I would like more elaboration on that. What if the domain name is used by another entity who is not under my control?
Yeah.
Just not under my control, using it even a good version. Shall I not be illegal now to complain or to do something legal against them if they are using it in a good manner?
Well, if they're doing it in good faith, is actually the second requirement. So they have a right, acquired a right, to use the domain name. But we will deal with this in a lot of slides afterwards. You'll see that it's really very important to define which is the level of the good faith or the bad faith, because it really varies. Is it this well-known trademark? It's really difficult to think and to argue that they are using it in good faith. They knew about it, and maybe not now, but in some weeks' time, they will start using some commercial advertising, some attempt to sell domain name, so maybe even a temporary use. If it's not well-known trademark, it's really difficult even to conceive that you have a good faith interest. But should that be the case, I would not advise my client to use a UDRP, because then I will lose on the second element. Yes?
In case the domain holder has a name that may give you the idea that he's working within your organization or something like that. Is it a similar?
Like a distributor or a representative?
Like we in the Arab League have, as an international organization, have many sectors and other smaller organizations, sub-organizations, in which they are in economic and social and in so many fields. And there are always websites about organizations that pretend to be an Arab organization. So we don't have the same name, but its potential work in the future. So in this case, can we?
But you really have to assess always the legitimate use or not legitimate use. It is an entity which can be entitled to use this denomination. It is supposedly a trademark as well. It's just a different Arab League or something like that.
It gave
the impression, so it's misleading. But again, to act, you have to have a trademark registration, and they should be targeting the trademark registration owner. And then you have to evaluate whether it's a good faith use. It has only, for instance, if he's only a fan or a distributor or a person promoting the interest of this organization, it can follow under this legitimate interest concept. and it's going to be up to you if you are defending this entity to demonstrate it, because you have to prove the negative if you act in but anyway, the assessment is complex, and that's why we have to deal with this in details. But the short answer is, if the interest is legitimate, you will not use EVP. If you can prove bad faith, that can be one thing. Right? So, this is to be remembered. I will ask you a question about it later on, of course. You don't expect me not to go back on this issue. Yes?
Yes, a quick one. So are there any guiding principles on what's confusing these similars?
Of course. We did about 30,000 decisions in this, and you'll have a lot of guiding principles in the overview documents, which I will talk about later on. But confusing similarity is a complex anyway matter. We don't adopt the trademark confusing similarity always per se. Certainly we have guidance on the trademark issues, so it should be apt to confuse the user as to the source of a given product or service coming from the web owner. So basically, if you have, for instance, a Gucci website with all the images of the products of Gucci, it's certainly apt to cause confusion. If Gucci sells, I don't know, different, so Gucci is a well-known, so it's a bad example. So it would enjoy a large protection, but should not enjoy a large protection. And if you sell tissues, then it's not going to be confusing symbol. So it's a matter as well, the evaluation of the trademark per se, and in a minor way though, the evaluation of the content. But as far as the first element is concerned, the threshold is very, very low. So you simply have to assess the confusing similarity. So if it is only composed, theater and eat, a trademark, theater having heat in that there is not confusing similar. But if heat is a trademark, heat focus something, then you focus on that one, and that is confusing similarity. Right? So we have to evaluate case by case basis. But the principle is similar to one trademarks, even though we do not apply per se the trademark principles. Right. So now we told our clients, yes, it's a go. We can do it. We have the elements. They're all there. What do? Now we start writing a complaint. And what do you write? Well, this is the most boring part, I know, but you have to make sure that, hey, you have to select, I'm just skipping some. Am I missing one slide here? Probably yes. Okay, I'm sorry. The trademark should complain anyway. You have to. I was deleting one slide. I apologize. I will place it back. Anyway, the slide was speaking about what you have to have as a first requirement. You have the text anyway online. You have to mention the trademark. You have to mention who are you acting on behalf of, or if you're a trademark holder, if you're acting directly on behalf of the trademark holder. And then once you've done, and you have to indicate which rule you apply, which are the rules, which is a UDRP, supplemental rules of WIPO. Then you have the compliance rights, and you can go for one single member panel or 3-member panel. This is procedural. Why do you want to go for a 3-member panel? Have an idea? More costly.
Be an odd. And an odd number.
Well, it can be more tricky. The panel deciding this is a body of about 450, 500 lawyers worldwide, experienced in this field. But coming from different jurisdictions as well. So you have Americans and you have Europeans as two main groups. Should you have, for instance, an issue delicate, like for the free speech? The issue is, for instance, is a company supposed to be using a trademark in the domain name to freely speak about a given product, to criticize it, for instance? Is it necessary to have a domain name contained in a trademark to say that Gucci products are not good, or is not? Well, American lawyers would tend to look at it in a way which is more like free speech, of course you can use it. And the European lawyer may have a different approach, say, well, why do you really have to tell the same thing? You can have exactly the same website, but without mentioning Gucci in the URL. Why do you have to have a domain name? It's simply helping you to have more people looking at your page in which you're strictly not happy about the product good. So it's really an example in which I would go for a 3-member panel. Because if you do a 3-member panel, you pay $4,000 as opposed to $1,500. But you got to select 3 panelists. You as a complainant put a list of 3 panelists when you file the complaint. And you know that one of them is going to be deciding your case. Because WIPO is that WIPO or whomever is the dispute resolution provider is supposed to pick one of those. Right? So this is a good way to select maybe some European lawyers, if you have an issue like I've just described it, that you know there's going to be say, well, what the heck, it's not needed to have the trademark in the domain name, therefore the domain name should not be maintained by a respondent. The respondent, likewise, will name 3, in which they pick some US lawyers and some other people that I might simply say, well, it's free speech, come on, you have to be able to speak openly about what is a problem about the trademark. Therefore, I will decide in favor of the respondent. And then the precedent is selected amongst a list of 5 names that each party is supposed to rank in order of preference. So at the end of the day, you will have 3 panels per party, one of which is going to be decided, and then the list of 5 panels, different ones, selected in order by both the respondent and the complainant. The panel who will be higher in the list of both prepared by the respondent and the complainant will be the precedent of the panel tree. Right? So you'll have a rather, I would say, balanced way to appoint a 3-member panel. Now we have to 3 years to go, because I know you're afraid. I apologize, this is a boring stuff, so I expect you to be here tomorrow morning. It will be more entertaining kind of thing, but this is a way to establish it. And I have to tell the lawyers the tricks, how to do this, and think about panels of 3 if the matter is complex. Yeah, I did hundreds of domain names complaints. I used panels of 3 4 or 5 times. Because it was a bit more difficult kind of situation, I want to make sure, but in general, the single panel is fine. Typically, is the respondent asking for a 3-member panel. Therefore, you file the complaint for a single-member panel, and the respondent say, hey, wait a minute, I have a legitimate interest here, and I want to make sure that the single panel does not overlook it. Therefore, now we stop the procedure, and I appoint the 3-member panels. In this way, I'll pay $2,000 instead of $4,000 that you have to pay as you file as a complainant with 3-member panels. In this case, we split the fees. The complainant pays $500 on top of the $1,500 he paid, and the respondent, for nominating the 3-member panel, pays $2,000. Even and balanced system. Right? This is a tricky part, but it's nice to know. Complex matter, 3-member panels. Straightforward, go for the good ones. WIPO, but for myself, has a good level of knowledge in the panel, so it's valuable. So, what about name of respondent? Name of domain names are subject. The complaint is of course requirements. You'll find it in the rules, but I like to go over these requirements to teach you the tricks. I don't have to tell you what to write, but I like you to know that you have to bear this in mind. Always to do the check of the requirements and make sure that this is a part you consider properly. That, of course, you have everything you can dream of all the panelists, over 400 people, because we are public. So if you do something bad, it's going to be staying forever, and your resume is already published in different websites. What else do you have to write? Well, the registrar. You recall that I mentioned the registrar, the entity you're using for registered domain name. You have to mention the trademarks on the service marks on which the company is based. Make sure that you provide us the element. I will not stop telling enough with this kind of environment that you lawyers have to do their work. I'm having the hat of the panelists now. I don't want to receive any complaints of any of this room without the indication of trademarks. Provide me not a pile of papers like this with all the registration in the world, but at least one registration. You would be surprised how this procedure are still entrusted with people maybe not experienced enough in a firm, or the younger lawyer come in, and they provide this procedure, they take it for granted. I take it seriously. If it's coming from a serious law firm like the one organizing this event, I expect the lawyers to be knowing this. I expect them, while I'm prone to do the extra mile for a single respondent or complainant acting on himself. If they do get the qualified assistance that we can get in this room, I expect, when I'm acting as a finalist, to receive this information. It's easy, it's written there, do it. Trademark registration. Not the entire story of trademark registration worldwide, we need some evidence that the domain name was corresponding to it right. And I want you to motivate it. I don't want to do the homework for you. If you write a complaint, be succinct. You have 5,000 words. But do let me know why you think your clients have trademark registration, the complainant, the respondent does not have original right, and you have bad faith at the time of registration and in the subsequent use. Make sure you provide us all the evidence. I'm sorry, this can be maybe sounding obvious, but I tell you, I do this work since 15 years, and since nowadays, 15 years ago, okay, new procedure, you're not known. After 15 years, you still get from large firms complainants that are badly written. I would have used another word, but it's videotaping, so I cannot say what I think. But it's surprisingly bad, and we, as finalists, decided to be stricter. Right? We meet every year in Geneva, and we discuss all the different district, high-level discussions. One of the points was, let's be fair, let's apply the rule. Therefore, we should have the elements in which decisions should be made. Right? So, what else? Well, this is interesting as well. The rules, UDOP, provides for the jurisdiction. As you know, there is a procedure whereby the respondent, should they lose the procedure, can file a court procedure. Within how many days? Anyone knowing how many days you have to file a procedure in a court after the decision was rendered? 10.
10 days?
10 days. So you got to be speedy enough. So if you do it, if you are a respondent, if you're assisting a respondent and you lose, you have 10 days to go to court. Where do you go to court? To the court of mutual jurisdiction. You cannot go anywhere you wish. Because at the time you draft the complaint, you, complainant, pick the court, which you can either be the court at the location of the registrar, the company selling the domain name, so to speak, or the jurisdiction of the registrant, the respondent. This seems to be obvious and easy. It is not. Many pirates use difficult jurisdiction, different jurisdiction, complex jurisdiction, that pretend to be based in even places where simply the language is a barrier. Think about that you have to translate in Korean because the respondent claims to be based there, even though it's based in Korean, but he uses a registrar in Korea to force me to translate everything in Korean. We'll come back to this in a minute. But this is, and Korea could be one jurisdiction for the mutual jurisdiction. So, watch out to pick the right one. If you have the option of the two, pick the right one, or if both are okay, you can even select both. But bear in mind that you will be obliged to go there, nowhere else. Okay? General powers of the fund. It's lovely to be a fund, because we can basically manage the procedure in the way we deem appropriate. Within limits, of course, but we have to apply the policy and the rules, and that's it. And overall, we have to ensure that the parties are treated with equality, and each one is given a fair opportunity to present its case. Seems obvious again, but again, I have to decide cases in which the respondent was not sure enough, but I will still decide it in his or her favor, because it was obvious that the complainant was written in even bad faith. There is a procedure called reverse domain name hijacking, where the big company assisted by big law firms say, oh, you small guy, give the domain name back to my client, even though the client last name was corresponding to his real name. The client, the respondent activity was small, but was actually different from the trademark registration. you have the second requirement, the legitimate interest. You should not do that. Sometimes it is a temptation, and I come across some of this, but watch out. So I have to make sure that I treat it with equality. We also should make sure that we are speeding up. We have 14 days to decide, which seems to be a long time, but we are typically easy lawyers, so we don't spend 14 days in deciding. You decide it the last day, and sometimes it's more complex than you expect. The bad thing of being an older panelist, being one of the 6 trainer at the advanced UW course all in Geneva, means that you take only, and you get to decide only the bad ones, meaning the difficult ones. And you get the same amount of money, which is $1,000, which sometimes is a pro bono kind of activity, but we do with pleasure because basically we build the law or the jurisprudence in this field. So I do it with pleasure since 15 years this work, and I love to do it because it's a way to solve these kind of specific problems, to help ICANN and the organization to manage this kind of specific infringement on the line, and to help the system to work better. So it's good to do it. We have to determine as well the admissibility, relevance, and materiality and weight of the evidence. If you acting as a respondent will tell me as a panelist that Armani-Giorgio.net is your dog's name, Armani, Giorgio, says, is not admissible, is not material. Don't do it. We'll spot you, but it happens. So we have they make up invented arguments. They really create funny sometimes stories, but not supported by any evidence. So if you do say that Armani Giorgio Sith is the dog's name, maybe you provide a witness statement, sworn witness statement by 100 people, say, well, it's really his name, his dog is called like this. Maybe I'll believe you. Maybe. If you say it, it's not relevant enough. Right? So make sure that we are happy to defend a respondent. You make sure that what you are quoting to me as a panel is credible, because we assess the materiality of the weight of the evidence. And basically we can as well consolidate multiple domain names into the policy. For instance, we have a country code procedure registered by the same entity as a generic one. You can consolidate it in a single procedure. The language. Which language do we apply? Yes. Difficult. It's actually complex because they thought that was a good idea to apply the language of procedure, the language of the registration agreement, which means that you have registered domain name in Korean, you have to do everything in Korean. And if you did it on purpose to make the procedure of a complainant harder, that's a problem. But this is a general principle. But if we manage, having regard to the circumstances of administrative procedure, that, for instance, a correspondence was ongoing, and we'll talk about it tomorrow, with the respondent in English, if the website is in English, why on earth should I use Korean as a language for my procedure? Simply because the respondent was shrewd enough to use a Korean registrar to do the domain registration. So this is a kind of thinking that you know, taking this kind of courses, but the procedure says the language of the registration agreement. You cannot prove that the counterpart speaks any English or any known language of Egyptians, to what we need to know. Tough luck. Then you have to go in Korean. But if you manage to prove it, you have the circumstances helping you, and we can decide in that language. What about documents? Well, if we have Korean, we have to do everything in Korean, or we can as well admit the evidence in other languages, depending on the language skills as well of the panel, and a number of factors. In-person hearings. Do you think we'll have in-person hearings in this procedure? Yes? No? Yes? One. bad luck. Just a test if you are ready. No, actually we don't. But you actually can be true, because they are not in principle, because it's a procedure which is supposed to be quick. It would be fantastic to have in-person hearings. I would love sometimes to ask, why on earth you say that Giorgio Armani is a dog name? You said, talk to me, tell me. But you don't do it. What you do sometimes is asking additional evidence. I issue procedural order. If you say, well, the trademark is well known. Right, never heard it. Why is it well known? Provide some evidence. You did advertising, explain it. So this is the kind of issue that we can basically do. Otherwise, we don't have any in-person hearings. Decision in default. Well, this is part of the beauty of this procedure. It goes on. No matter if the respondent is there, bear in mind the respondent can be often based in different parts of the world, very difficult to get a hold to. Therefore, if we would need to wait for an answer of the respondent, we would be really having troubles. It doesn't happen, it's not needed. Once the 20 days are gone, tough luck. That procedure goes on. So we go to a complaint to the procedure. Of course, if there are some exceptional circumstances, there was an earthquake in the city where the respondent is based, or you can provide evidence that there was in the hospital, fine. We can extend it with no problem. But in absence of exceptional circumstances, the rules are clear. 20 days or we proceed. It doesn't mean that we are deciding against you if you don't show up. Obviously, we infer from your conduct, if not motivated by the fact that you were in hospital, that this could be a problem, that you don't care about the remaining. If you would really have a legitimate interest, write me one email, not even draft the entire response, but let me know that you care about it, and that's why you care about it. If you don't show up, I may think you don't care about it. You don't have this legitimate interest. And when you drafted a complaint, you have to prove the negative, so you have to prove the absence of. So once you prove the absence of legitimate interest as a prima facie level of evidence, the burden of proof is then turned into the respondent to tell me, as a finalist, I do have a legitimate interest. If you don't do it, I can infer that you don't care about it. Right? What do we write in the complaint? Say, oh, this is a crucial part. Right, so the policy and the rules provide for 4 main, let's say, circumstances evidencing bad faith. Another part to remember, a little bit. So you have to wake up a little bit. Again, that slide before and the next couple of slides are important as well, because you have to think about the evidence of bad faith. How can I prove it? Well, first one. Before any notice of demonstrable, absence of bad faith, it has legitimate interest. For instance, if you're acting for a respondent, you may prove that before the domain name was object of a complaint, you were using it or preparing to use it in connection with the bona fide offering or good services. So you thought that was a good idea to promote this business, and before receiving notice that I had a trademark corresponding to it, you were doing it in good faith. That's a good argument that you can respond in a response to the complaint. Or you can mention that the respondent is an individual, business, or other organization, and being commonly known by domain name. Not like in the case of Giorgio Armani, but like in the case of a guy whose last name was corresponding to a trademark. He then became my client, but then was not my client, and there was a complaint filed for perfecti.net. So, complaint filed against a person whose name was Fabrizio Perfetti. The last name was corresponding to the trademark of the client, of the complaint. Well, no evidence whatsoever was on the website that this domain name was used for advertising services or products in competition with the Perfetti ones. No advertising or other products was ongoing. It was a single page by the guy saying, well, I'm from Mr. Perfetti, I do this kind of business. No relationship whatsoever. Perfetti is the one producing Mentos, Chupa Chups, you may be familiar with this, candies. So, large corporation, but unfortunately for them, actually it was one of the longest conversations I had with an in-house lawyer. I was in San Diego walking back from a reception, and he was really telling me, why did you decide against us? Why? And I had to explain, well, you had to provide me evidence that this guy was acting in bad faith, and he was not having a legitimate interest. His last name was this one. You don't provide me any evidence. And then admitted, well, yeah, right. At the end of the day, we just tried it. We lost it tough luck. This should not happen in principle, but it may well happen if you get a picky panelist as I am, because you have to prove that you don't have a legitimate interest, right? So, third element that you can successfully write in response, and to prove that you have a commercial or fair use domain name without intent of commercial gain or misleading diverted consumers or tarnishing the trademark. So basically, if you're acting in good faith and using the domain name, not infringing the trademarks of the complainant, there you go. You have a legitimate interest. Thus, you cannot apply this procedure. But now, let's turn page. We get rid of all the issues that are related to the respondent, and now we're acting for our clients. The complainant. And now we have to prove the third element. You recall? Bad faith at the time of registration and in the use. How can I prove it? Some ideas? Well, that rules help you. 4 different circumstances. First one, you have registered domain name or acquired domain name primarily for the purpose of selling, renting, or otherwise transferring domain name. Who is the owner of a trademark or service mark to the competitors, to the complainant, for a valuable consideration in excess of the documented out-of-pocket cost directly related to the domain name. So, long story short, you try to sell this domain name, but selling is not enough. It should be for an amount which is in excess of a documented out-of-pocket cost directly related to the domain name. Thus, if you offer a domain name for $50, $100, $200, according to this circumstance, is not enough. Because you have to have a consideration in excess of the out-of-pocket cost. It seems easy, but there's a lot of discussion behind it. Is it bad faith, $50? Yes. Yeah, it's a classic case of self-squatting. But if I sell you a domain name for $50, it's not in excess of the out-of-pocket cost. So if you only have that element, everything else is clean. There's white page, nothing online. You write me and say, well, what do you want to do with this domain name? And I tell you, oh, I can give it to you for $50. That is not sufficient to evidence bad faith. If I ask 500,000, yes. 5,000, yes. $50, no. Because it's not in excess of documented out-of-pocket cost. Clear this small but important difference? Second, what about if you have registered domain name to prevent the owner of the trademark? Easy. You are occupying my presence online. But, again, a caveat. Provided that you have engaged in a pattern of such a conduct. Thus, if you only have registered one domain name, you ask $50 for it, you're still missing evidence of effect. Because you don't have a pattern, and the consideration is not in excess of that. Right? Tricky, but important. Third requirement. If you register the domain name primarily for the purpose of disrupting the business competitor, without caveat. If you say, let's say, this product sucks, borderline prestige, but if you, by the way, this product sucks, and this product is much better, and I'm the competitor doing this, or you're disrupting the business otherwise, it's bad thing. Yes?
Okay, I have a question here.
Please, I was hoping to get some questions, get some water. You know. Just kidding.
If someone buys a name that's not related to him or his company,
This is very noisy.
if someone buys a domain name
Yeah.
that is not related to his name or his company or so,
Yeah.
but he bought it because he is making sort of business, because the owner of the domain will buy him in a higher price.
Right.
So the owner of the domain or the legal one who should have it may come back to you first instead of pay this amount of money for this one who bought his domain name.
Well, if the sole purpose of buying it was to sell it to the legitimate owner, that's evidence of the theft. Unless you ask for $50. Right? If you think, oh, this is just Ajit, it's a nice offer, big, 82 offices, 2,000 lawyers, they might be interested in Ajit.law. Why not I register it and then I sell it to them? Is it bad faith? Probably yes. If I think of Ajit as I don't know, there's an Italian company selling gas called Ajit, but unrelated to law firm. And then I say, well, this Ajit company is selling the gas much more expensive than Esso or other companies, and I do fan or let's say, I wouldn't say disrupting page, but simply a page speaking not fine about this, but without infringing the rights. This is a legitimate page in which you express your ideas, which can be questionable, but is not targeting the law firm. That is not bad faith against the trademark owner. Right? So this is a bit different. Yet, if I would say, well, Studio Barbero is much better than Ajit, and by the way, click here so you end up in the Barbero sources saying the domain names cheaper than Ajit, then it's a problem if I do Ajit.law. Right? Even if I don't sell it to you, because that would be the third problem. It's a very much fact-intense procedure. And that's why the intelligence you do first, the work we talk about tomorrow between 11 and 1 o'clock, the kind of tricks that you have to follow to acquire evidence of the trade are very important. Oh, thanks so much. Because at the end of the day, if you provide the panel evidence that bad faith is there, you win. If you don't, there's a problem. Sorry, to get some water. Client's water, so perfect.
So what?
Yes, I was hoping for a question. What are you doing? Thank you.
No.
Go ahead, no, please. That's exactly the moment in which you ask question.
What if the top level domain is already .sax?
That's a lovely example. As you know, one brilliant company thought of registering .sax as a new generic domain. And then was distributing condoms in front of our meeting in San Diego. Imagine a bunch of IP lawyers getting condoms, say, well, this is .sax, advertising .sax, and selling the fancy registration for $2,500. If you want to have a Gucci.sax, you pay me, registrar, $2,500. Okay, this is, I would say, even the registry in favor, to some extent. But if it's not the registry, it really depends on what you want to do with it. By definition, .sax is a registration you do that you don't when you don't like the product. So you either do when you don't like the product, or you, as a trademark owner, you want to avoid that someone else has it. But as it was an extortion of this proportion, as it was asking $2,500 just to have it, threatening you that adding you registered it after the sunrise period, if an organization wanted to buy it, they could have added for $100. Hey, come on. So the entire registry of records was a bit problematic. So, and therefore, if you registered .sax for the purpose of reselling it to the trademark holder, paying half the amount of money, because even when it was at the first come first served, there was still a significant amount of money, it's certainly bad faith as well. So no matter about .sax. If you, on the other hand, want to say, but Walmart sucks, there was walmartsucks.com, classical case, but now at walmart.sucks, to say, well, the products Walmart are terrible and I don't want to queue there, again, can be a legitimate interest. if you don't have any advertising, if you don't have any link. So again, as I mentioned before, it's a fact intensive, but the extension now play a role in which it's actually interesting because the new evolution of the new generative domains help us to make a determination. Before, it was always irrelevant to assess bad faith the top level domain. So by definition, we were going, in light of the fact that the .com, .org domain are not relevant to the domain name, we consider computer similarity as opposed to it. But now that we have an extension which can be suggested of the purpose of the trade, you have cars. If you do register Audi.cars, of course, you aim at the owners of cars. And it's more apt to create confusion into the owners as opposed to Audi.whatever, or Audi.bank, which is unrelated to the cars. So this is an interesting evolution which was we are facing now of changing even our jurisprudence, because we were always saying it's not relevant. Now we can say it is relevant. To some extent it's relevant. It is even more relevant because the top level domain is enhancing the confusion similarity. Because if it's related to the product, of course, it makes the domain name as a whole even more potentially problematic. So, the fourth requirement, going toward the end, is, and we said 19 minutes ago. I'm sorry, I apologize. So, you are attentive. Sorry about that. So, the four requirements, and there we may still, we'll maybe even end in 10 minutes before, because I see you are tired and this is very difficult stuff. But it's important because this is the basis of the procedure. You have to know this if you want to file a good complaint. The fourth requirement is the most famous one. The fourth requirement is this one. By using the domain name, you have intentionally attempted to attract for commercial gain internet users to your website or other online location by creating the so-called likelihood of confusion with a compliance mark as the source, sponsorship, compliance affiliation. So, this is a requirement, in essence, in which we tell you, if you do register domain name and try to make yourself pass it off as, or believed to be connected, sponsoring the trademark, you are in bad faith. No matter how much money you ask for it. If you're basically having a web page replica of the official ones, that's bad faith. And this is the most important one, actually the most commonly used. Could be even sufficient to have this element, but you have to prove it. Yeah? Once you have proven it, this is a perfect circumstance evidence of faith. Tricking us poor internet users. And this is the fourth one. We don't have only those. As we are lawyers deciding all this, we have additional ones. So those are the four ones in the rules that you can always rely upon. If you don't have any of the four, you may still find bad faith if, for instance, you have other circumstances that we have developed in our jurisprudence. Say passive holding. What is passive holding? When you stick the domain name and you don't do anything about it. For months, years. You don't do anything, you don't sell it, you don't you think about the four requirements, nothing applies, but the fact that you're occupying a space for years without doing anything. Is that bad faith? Yes, it is. Tesla. Decision number 3, 2000, Tesla Corporation. False with information. You know you have to declare who is the registering domain name when you file a domain name. If you use false data, that's a good indication of bad faith. If it is impossible to consider a legitimate actual contemplated use of domain name by the respondent, classical example, well-known trademark. It's impossible to have a Coca-Cola dot whatever without anyone in this room thinking about Coca-Cola. Even if you are living in Mars, when you get to the world for a couple of days, we come across a Coca-Cola can. Lunchtime today. Therefore, it's impossible. Bad faith. The respondent knew or should have known about the trademark. Campari Mix was a ready-to-drink like Campari Breezer, introduced in the market some years ago by my client. and was registered with the guy was registered in CampariMix.net, .com, and .it. Before, the product was launched in the market. But after, there was a presentation to the people operating the field. The owner ended to be a barman, actually the owner of 3 bars in the area of Rimini, who was present to one of these presentations. Trademark registered in April, product launch in September, but in July, here is the main name. That's it. Mouse tracking. If you go to a website, you cannot go out of it. Hyperlink to pornographic websites. Perfect. Typo squatting. Do you recall the Nesquik case? It's called typo squatting. 1 letter makes a lot of difference. You name it, you have a lot of information on this. Example of false reads. What about Edison.net? Registered by Bond James. My name is Bond James. Of course, this is Bond James. It's not really a physical role of a secret agent, so, and I was pointing in this page. Dissenting opinion and reverse domain name hijacking. We are 3. We decide at majority. We are lawyers. We often disagree. It's a painful procedure sometimes to decide a 3-member panel, and I always get to be the president lately. It's nice to be a member of a panel so you can play around with the president as well. I got appointed yesterday of a very complex domain name case, and I'll be the president, and I'm already thinking about the amount of time this decision will take me, because I know the panelists will be giving me a difficult time. I try to work the procedure in a way that we reach an agreement, therefore we draft one decision, but if you don't manage to convince one of the 2 panelists, which are not thinking the same way as I do, to reach a combined position, we can have a dissenting opinion, whereby the majority, 2 panelists, issue a decision, and the 3rd panelist say, well, no, it was like this, because I believe this. And it's fine. Sometimes I will be in the minority if I really believe in something, but they go that way. And it never happened to me, because basically it's a fact-intense case, so if you study well the facts, you end up with the right or possible resolution, and you have a body of 30,000 decisions to help you. And you have the overview, which we'll see tomorrow. But anyway, this is an issue of dissenting opinion. What about the reverse domain hijacking? This is very important. I was mentioned already about the big corporation and the big trademark and the big law firm against a small guy. This is a classical case in which we should not trick the procedure to act in your favor. It's important that even be a big law firm, you think twice and think about the second item, the legitimate interest. If you think that the respondent has a legitimate interest, don't file a complaint. Now we're getting nasty about it, because we're fed up about the situation. The rules are clear. Fed up is a big word, but at the end of the day, we want to be stricter in applying the rules. Enough is enough. So, if you are tricking the rules, if you are aware of the fact that the legitimate interest is there, if the last name is correspondent to the person, you don't file with your PIN. You talk to him, you get in touch with him, we'll talk about that tomorrow. You provide a body of evidence before. If you file only the complaint, say, well, this is a big company, this is a big law firm, you small should give the name back to my client, even though you're doing an honest business, having a car repair shop called Gucci, which is a well-known trademark. But again, if you're a car repair shop and you do anything connected to Gucci, but your last grandfather was called Gucci, and that's the reason why you could have it, don't file a complaint. Check it. So, in this case, we can file for reverse domain name hijacking, which basically is telling the complainant, don't do it. Actually, this was playing a role as well in the new generatable domains, because if you were, as complainant, having 3 decisions against you with the domain name hijacking, you could not have filed the application for a top-level domain. So bad. Yeah? So if you're a big company, say, I cannot add even .Gucci, should have my client Gucci add, for my mistake, add 3 decisions with the reverse domain hijacking in the history, or 15 years, they could not have applied .luce. They would have killed me, possibly, but they would not have been entitled to file. So this has value to the others. And now we're trying to be stricter in applying the rule. Because the rules are clear, we have a body of decision, so don't fool around. If you are in some doubts, don't do it, unless you're sure about it. Reverse domain hijacking can be always fine when the complaint was brought primarily to harass the domain name holder. Because they may even say, oh, okay, there is a big company, oh, there's a big law firm, I give up. Unless they are really stubborn and say, well, I know the procedure, I attended this presentation, those ICANN organizing these courses, I know about it, thus, I resist, I write a response. I have a legitimate interest. It's serious stuff. You have to know. Panel shall decide the complaint on the basis of the statement documents. So what I told you is important. Do provide us the documents, the evidence. Make the effort. Do the work and trust the matter in a company which can provide you evidence that you can use in this procedure. And in absence of separate circumstances, we have to provide the decision in 14 days from its appointment. So we basically have to decide in 14 days. And they are really strict in applying this rule. On the 14th day, you say, Dr. Barbero, you may recall that you had to file this decision by today. Please send it to us. If you're missing the deadline for some more days, you say, well, what about the decision? So really make sure to make the decision on time. And it's important because, of course, we have to provide the entire system to work well. The entire system to work smoothly, to be quickly enough. 3-member panels, as I've already mentioned, have to be taken by majority, and the panel decision should be in writing, and therefore we should provide the grounds on which it's based. So we don't write dissertation, but we tend to write a reasonably motivated decision when we issue a decision. The remedies of the UDP are the following: transfer, or less common, cancellation. Cancellation is, of course, used in less than 1% of the cases, because, of course, once you try to cancel the domain name, it gets re-registered after a few minutes or seconds by either the same entity or entity connected to it, to this. While the URS, Uniform Procedure for Suspension, is simply obtaining a suspension. It's a new procedure which was introduced for the new generated elements. We talked about that tomorrow again. It's a procedure which has a different threshold of evidence, but the only aim of a URS, which is only applicable to the new generated elements, is to obtain the suspension of the domain. Appeal and court proceeding. Neither party has a right to appeal the admin procedure, the UDP, but the parties, as I mentioned already, are entitled to commence a court action in the court of competent jurisdiction, as defined before, the two mentioned. Should the court proceeding be initiated in 10 days, the implementation decision will be suspended. So basically, is it sufficient to provide evidence that you have filed a court action? Sometimes they even trick WIPO and the panelists into believing that the procedure was initiated by, for instance, submitting, it happened to me, in Korea. They were submitting a fake legal procedure in Korea, which was, they didn't pay the taxes. So we stopped, we couldn't transfer the domain name, was Benetton.org, I think. And after I managed to prove that the counterparty, the respondent, was only faking to have filed this procedure. But in general, if they can file it in 10 days. Timing, and that's the last slide of the day. Well, you file the complaint, and then usually in 5-10 days, the resolution service provider does the verification and sends the procedure to the holder. Now, this procedure has changed with a new procedure. We'll talk about it tomorrow, but I can anticipate it now. Because the complaint is not notified anymore to the respondent, because there were some cases of so-called cyber flight, IDEST. You, as a complainant, file the complaint and letting ICANN, the respondent, know at the same time, and the registrar. The respondent typically, in that very moment, tells the registrar, okay, transfer the domain name to who is Privacy Shield. It has a company hiding the identity, or to my brother, my sister, not having the evidence of the faith. To avoid this, the procedure was changed in July last year. Therefore, the complaint gets not notified immediately to the respondent, but only to the registrar and to WIPO. WIPO then gets in touch with the registrar, and we introduced the so-called blocking system, whereby domain name subject to a complaint gets blocked, frozen in the name of the respondent. Then the complaint gets notified to the respondent. So this is a new evolution of the procedure which was introduced. But anyway, this happens anyway in this amount of time, and within 20 days, the respondent should write a response. If he or she or he doesn't do it, tough luck. The procedure goes on, and in 5-10 days, the resolution service providers appoints the panel and determines the timing of the decision. It just nominates me or some other panel as panelist, and then this determines that the decision should be rendered by a given date, 14 days after the nomination. Once this is done, we have 14 days to take a decision and to send it to WIPO. Then typically it gets notified to the parties, and from the moment in which the decision gets notified to the parties, unless the respondent or the sacrament party, to some extent, presents a co-proceeding within 10 days, files a co-proceeding in 10 days, the decision gets implemented. And the beauty of this is that it's the registrar itself to implement the decision. Because of the fact that they have this agreement with ICANN, and they run the risk to lose accreditation should then they comply with the rules of the UDP, the domain names get stronger by the respondent. We have to say that ICANN is getting much better in implementing this, and the procedure is getting smoother and smoother. In the past, there were some issues with some of the provider registrants who are not complying with the procedure, but now the procedure is really implemented. As the risk too much, they will not be able to do business anymore. They lose their accreditation. So the system works very well because the decisions are implemented directly by the entity registering the domain. And with this, I'll let you meditate with this white slide on what I said in the night, and I'll talk to you tomorrow about the WIPO experience and the monitoring activities, more practical stuff. So tomorrow morning we start at 9-ish, and we get the part of the WIPO experience, so we go over some procedural stuff again, we take a coffee, and we go into the details of the monitoring you can do and the practical approach for the reclaiming of the domain. Thank you for your attention. Unless you have some questions?
Yes, I have a question.
Good. Okay. Usually I may take in questions this time. I'll tell you that. Please.
My question.
Sure.
Okay, we'll see you tomorrow.
See you tomorrow.
So much for your informative.
My pleasure. My pleasure. Bye-bye.
Regarding the applicable law or policies, applicable rules or policies on the that the panelists apply on the testament.
Yeah.
Is there a general principles or main rules could be applicable applied on districts and actually pushed by the organization in charge to regulate the ICANN or WIPO?
Actually, the procedure itself says that we, as panelists, are supposed to apply the rules that would be more appropriate and apt to the specific issues. For instance, if both parties are based in Egypt, we may look at the Egypt trademark law to define the issue. But it does not.
Procedure.
They don't even in a substance. Even a substance. So basically, we consider, for instance, the trademark confusing similarity according to the Egyptian law, because we take for granted for both parties are from Egypt, they should be bound by or complying with or aware of the Egyptian law. If though, to the contrary, it's a Korean and Egyptian, maybe it's different kind of procedure. So there's not one entity basically imposing upon us the way to apply the law. We are, as stated in the procedure, supposed to and obliged to apply the rules of law that would be more appropriate to judge and decide things.
At least to illustrate the right issues or the rules or actions could be considered as abusing for the domain name.
Yeah, I mean, of course, we have as well a body of decision that we refer to. We have issued documents which is called the WIPO overview, which we'll talk about in details tomorrow. which is basically addressing all these tricky questions or more problematic issues, which is an example tomorrow. And in that case, we tend to comply with the majority as decided in 30,000 cases. And if we do not agree with the majority has provided, because, for instance, the facts of the case are slightly different from the one to which the general approach is supposed to be applied to, then we have to make an extra effort to motivate, to write our grounds and reasoning for not complying with general rules. But in principle, we have to apply the majority. Because one important issue is the consistency of decisions. Is the fact that if you have similar facts, you as a complainant should expect similar decisions. The problem with some of the other panelists and these solutions provided that sometimes this don't happen, especially with the URS now, which is a quicker procedure. You have to render a decision in a few days. You think less, you don't have a body to refer to. You have even symmetrically opposed decisions in a similar case.
Actually, you mentioned that in your example that the way case, a panelist, American panelist,
yeah,
and European one.
But that's still,
I think
that's an interpretation of principle of law. So in that case, that's why it's important to have a three-member panel, because then the applicable law will be a result of a discussion amongst the three panels, and one of the three will have to be in one opinion or the other. So basically, either one will manage to convince the third one having a different opinion, but in this case, the general principle applies, or we'll have the split decision. Majority going one way, dissenting opinion written the other way. But anyway, we got the solution.
But I think if there is a common principle or common definition for some kind of action we're using,
yep,
it will help.
Absolutely, and that's why we did an effort to do this WIPO review 2.0, and now we're working on 3.0, which is an evolution taking care and taking into account the evolution of jurisprudence in the last 7 years, which is the date from in which the prior review was issued. So basically, we have a new document coming up in the next month. We're revising it as we speak, where all this general principle of law or precedent, relevant precedent, are taken into account. Yes, you were asking a question.
Yes, about the decisions, I think.
Yeah.
It only includes that this domain name belongs to X or Y. It does not include any penalties or any blacklisting for the owners or something like this.
Oh, well, let me add, unfortunately not, but it's a part of the beauty of the system. It costs only $1,100. It's aimed at fighting these specific problems. It has the clear-cut cyber squatting cases. If you wish to have the awarding of the damages, you can go to court, or you can always go to court afterwards. Basically, you get the decision, you get the money transferred, and then you can start the court action anyway against the respondent in order to claim damages. But the procedure itself does not provide for any damages to be awarded. Yes?
What if you're talking about the CCTLD that, for example, does not apply to uniform dispute resolution procedures and has its own procedures?
Yeah.
In this case, the complaint, it kind of makes no sense to go through this because then you will not be able to enforce the decision.
You won't even be able to have the decision, because unless you have adopted UDP as a country court of government procedure, like in the 40 plus countries I've seen before, I'll see that tomorrow, you won't be able to use the system, IDES, WIPO, NAF, and the others, to implement the decision. You have to either go to court or use the ad hoc procedure, for instance, for .co.uk.it.eu. You have similar procedure, but which are rendered and managed by different entities. Therefore, if you don't have it, for instance in Germany, you have to go to court. You have a similar procedure to
First,
yes.
you should follow the procedures that this registry has, and then if you don't know where they're, then you have to.
Yeah, I mean, some of the registry do have some even mediation procedures like .nl, .ch, and some similar different ways of approaching the matter. But unless they have adopted the UDP, we cannot even refer to the matter. You can maybe quote in the court action, well, this is a classical case, and should it be subject to UDP, this would be blah, blah, blah.
And then which court do you go to in this case?
You go to the court you're competent, which again can be the same as neutral jurisdiction, because typically you have to file court in the court where the respondent is based, or where the register is based. But typically, when you have to file a court action, you have to go to the place where the respondent, the domain holder, is based. Unless you manage to prove jurisdiction by, for instance, making a purchase of a product sold by the domain name infringing the trademarks into a different countries, whereby you can eradicate the action in the countries in which the good infringing was exported. If you want to eradicate an action in the US, you have to make sure that this company, based for instance in China, does send products in the US. Otherwise, you have to file the action in China. Yes? I'm pleased about the questions, because I'm happy about the others. I'm really happy.
Like 4 questions, sorry.
Please, use this one going.
The first one is to what extent both parties can use the decision about timing and about if can third party use the decision and can it be used as an evidence of owning that domain name? The second question about can parties go to agreement within the procedures?
I'll take one question at a time.
Okay.
Good. So the answer for this one is basically in the rules itself. The pattern of conduct is exactly addressing this issue because you can, for instance, prove in another procedure that the same respondent was the subject of a procedure in X, Y, Z cases. So this becomes really relevant. The parties can always quote the fact that this party was infringing another trademark in the complaint itself. Therefore, this is very interesting kind of intelligence, and you can use as well the decision to act against the same party. So the answer is yes. Second question.
Can parties go to agreement during the procedures of this kind of resolution? And yeah, does it stop there?
Actually, this is a very good point, and we'll address it tomorrow as well. But WIPO, amongst the 4 dispute resolution providers, provide for the fees of the complaint refunded, part of it, 1,000 or 1,400, if the party reach an agreement before the panel is appointed. So once the UDP is filed, and this is often the case, typically you don't get a reply from the pirates until you really file the complaint. It's sad to say, unless you use some tricks that I will teach you tomorrow, it's more difficult to get a reply from the respondent. But often enough, when you file a UDP, say, okay, I'm joking. I was aware of the trademark and get paid, thus you get the money back. If he does that, or if she does that, before the panel is appointed, the complainant gets 1,000 of the 1,100 you paid back. So they can put the settlement, and this is enforced. Now, actually, the new rules that we mentioned before even have structured this kind of procedure, whereby we even have a settlement agreement, which is supposed to be signed by the party and sent to WIPO, and WIPO will be actually involved in the transfer procedure. Before was doing everything entitled to the party, now can somehow be more involved or somehow regulating the transfer of Let's skip one.
Can anyone find those published, issued decisions? Are they published?
Of course, yeah. All the decisions are published on the website. Again, tomorrow morning is the first thing when you wake up. You get all the information where you can get this decision. It's published on the WIPO in particular, published on the website of the WIPO website, and are researchable by item, by issues. It's a fantastic tool that you are available free of charge online to research privacy. All of them. Lovely. So, I really appreciate the question at this time of the afternoon. It seems that you'll be interested in this presentation. I'm really happy about it. So, unless there's other questions, you can always ask offline at the end of this session. I'll see you tomorrow morning at 9ish. Yeah.
Thank you.
Thanks very much.
Thank you, Lisa. So, just a quick announcement. We're having the dinner at 6:30 today. It's an early dinner with Egyptian standards, so very late. Very early dinner. And it's going to be at Baladina in Akan.